This is the Data Privacy Detective. It's February 29. Every 4 years it happens, So happy Leap Day to everybody. And we're going to talk about what happened this month of February 2024 in data privacy. And with the detective here is my good friend, Yugo Nagashima. Yugo, thank you for joining us again, as you do every month.
Happy to be here. Happy Leap Year. It's like the Olympics.
Well, it is. My sister got married on Leap Day, so she only has an anniversary every 4 years. How about that? But, stranger things have happened. But we'll talk about two very interesting things that have happened in February 2024 in data privacy. And before I do, for our listeners, Yugo is an esteemed data privacy technology and other specialist lawyer at the firm of Frost Brown Todd. He's going to talk to us now about a major development out of California. California seems to always have something interesting going on. So what happened in February in California data privacy, Yugo?
Big development. It's been the second one ever. California Attorney General has brought a complaint, a lawsuit, a CCPA enforcement against DoorDash, the food delivery service. And the parties just reached settlement for $375,000.
Okay, well, not chump change, not billions, but some. So why did the Attorney General out in California take issue with what DoorDash was doing?
This is very important because I think a lot of companies are not aware of it. So this is where everyone should perk their ears up. The AJ alleged that the DoorDash company has failed to inform customers about DoorDash being involved in what's called a marketing cooperative. And in there, what DoorDash was doing was sharing consumers' personal, by consumers I say individuals, right? Customers who are using DoorDash, personal information like name and email address, which was then used by the co-op members to send targeted emails or mail. The AG saw this as a sale of personal information. And the DoorDash basically failed to provide notice of sale of personal information and giving an opportunity to opt out of that sale.
Okay, and so does this go back to the year 2020?
It does. So originally, the AG noticed DoorDash that, hey, we believe you're doing this sale, you're using this co-op, and back in 2020, it is very important to keep in mind that 2020 was a big year because 2018 was when the CCPA came in play. And 2020 was when the CPRA was being passed. So back in the day, there was a curing period. And DoorDash could basically cure it if they would go back and say, we're aware of the issue, we're gonna be compliant. The problem was DoorDash could not track down the downstream advertisers who had the personal information that DoorDash had given. And a part of it was DoorDash didn't have the right contracts in place, agreements in place, to basically go to the downstream sub-processors or contractors to say, hey, we want to see what information you have. There was no audit provision.
So you're saying that whatever contract DoorDash had with its marketing partners, is that what it was? It could have avoided the issue if it had been better written?
I would say so. I would say that is one of the punchlines, what we can see in the complaint and the settlement.
Okay, so that was the allegation, and then the parties settled, and like in everything, I assume settlement says we're not admitting anything, we'll pay a fine, and off we go. But what did they really settle on?
So obviously they have DoorDash had to pay money, so that's number one. And let's go from the very high level. At the very high level, the AG required DoorDash to comply with the CCPA and a law called Cal-OPA. We usually talk about CCPA law. Cal-OPA is a law that's basically a privacy notice law, and it's more of the disclosure of information that's being collected. And more in detail, what the biggest cardinal sin that DoorDash made here was they were doing one thing and then they weren't really informing the consumers, right? They weren't being transparent. So transparency was a big issue. So one of the things that was required in the settlement was to admit or to put on their website and their privacy policy or notice at collection that DoorDash had been selling personal information. And that's one aspect.
Okay. Yeah, go ahead. Go ahead.
Sure. And not only that, it's really important. One of the things that is repeated in the settlement is clear and conspicuously noting that, right? So if DoorDash just hides it somewhere, it's not good enough. They have to make it clear and conspicuous. And that's an issue we'll find out as DoorDash fixes their privacy policy and notices. We'll see what is meant there, but it's got to be clear and conspicuous. So we'll see what that really means according to the Attorney General. So we should pay attention to that.
Yeah, what's clear and conspicuous? Not clear, is it? Or conspicuous? I mean, go to DoorDash and right now somebody's flashing. Watch out, we might do this. Of course, you can't do that. You're trying to appeal to DoorDash customers. So we'll see what DoorDash says. It'll be interesting, won't it? But that may address the kind of consumer public-facing website notice. But what about DoorDash's contractual obligations?
Right, very good point. So the contract side, the AG required a detailed description and evaluation of DoorDash's contracts with service providers who provide marketing services, specifically on personal information. So that's one aspect of it. DoorDash needs to review its contracts, and basically my guess, and I would do it if I was DoorDash, is to review it and put in any provisions that it needs to be able to audit. Because remember, one of the things that DoorDash couldn't do, even though they were told by the Attorney General, was audit the downstream contractors on what information that the contractors had, and they were stuck. They were in a catch-22 situation. So being able to provide that obligation on its contractors, right? Service providers to say, hey, when something happens, we have to be able to do it. Please provide the information is very important. The other aspect is, and this goes to more of just security of the data, DoorDash was required to review the technical and operational controls of all the service providers and contractors. So this goes a little bit beyond the privacy aspect, but I think the Attorney General is also concerned about how that information could be leaked or used in the wrong way through breaches and other items.
Well, good point. And boy, my goodness, it's going to be a challenge, isn't it, for DoorDash to police the entire supply chain of data? That's really sounds like what the Attorney General of California is insisting upon.
But that should be something that all companies really should focus on when they're renegotiating their agreements, because some agreements are old, and others that, with new contractual relationships, a company should be aware if they are implicated or if the CCPA applies, that there are certain provisions that you must put in, and those provisions are something that might save the company from being, the businesses from being enforced by the Attorney General.
Well, we'll see how that all goes. Thanks for that update out of California. Well, let's turn to the other side of the United States coast, state of Florida. February the 23rd, 2024, the Florida legislature, in an overwhelming bipartisan vote, enacted the Florida Social Media Act. This has been signed by the officers of the House and the Senate, sent to Governor DeSantis, who said he was going to think about it, that this is not all that easy to think about. We'll see how he comes out. But today I want to talk about the data privacy implications of a really different kind of law from what we've ever seen in the United States. Now, this has to do with social media, and we all have different views on social media. An awful lot of people participate in it, whether it's Facebook or something else that's popular, or TikTok or Snapchat and so on and so forth, YouTube. But a lot of us are concerned that kids are spending a lot of time, and so are adults for that matter, but children have some things we have to think about beyond until they're 18 anyway. Then they're adults and they can run their own lives. But this can be addictive. It can be invasive. Social media has its own set of privacy implications. Even if a child wants to participate in it, it can be very deleterious in some ways. There's no question about that. A lot of data about it. So what did Florida do? Well, in 2023, Utah, Arkansas, Texas, Louisiana, and Ohio enacted laws that basically require social media platforms, SMPs, if you want to use an acronym, social media platforms to get permission of a child's parent before giving an account to someone under 18, or in some states, someone under 16. Okay, well, Florida's effort goes a lot further than that. It amounts to a comprehensive ban for people under 16, young people, on some of the most popular social media apps. It also bars platforms from showing harmful materials to minors that include, quote, patently offensive, close quote, sexual conduct. So there are going to be First Amendment implications, but I want to talk more about the data privacy aspects today. Let's look at what would become, if signed into law by the governor, Section 501.1736 of the Florida Revised Code, having to do with social media use by minors. Okay, well, first, it would apply to someone where the social media platform knows or has reason to believe that the resident is located in Florida. Well, that itself might be hard to make sure about, but if it does, it'll apply. And it's going to apply to social media platforms that have daily active users who at least 80% of the days in a period are using social media. And then there are definitions that have to do with what social media platforms it really applies to. And there's an exemption to specific social media platforms that only do email and messaging and texting, not really what we think of as social media. They're exempt. But some of the big ones, the major ones that are used, are definitely covered by this. And then if they have 10% or more of daily active users who spend an average of 2 hours a day, and I'm going to have to figure that one out, then they have to do the following. First, they have to prohibit a minor younger than 16 from entering into a contract with the social media platform. Can't do it. And then they have to implement that, they have to verify the age of each account holder on the platform when the new account's created, using one of two things. That's quite interesting. We'll come back to it. Either an anonymous age verification method or a standard age verification method. And they have to offer an anonymous age verification method, but they can offer, don't have to, a standard age verification method, meaning one that isn't anonymous. And if they're both are available, then the potential account holder can decide which to use, which sort of wonders why somebody under 16 isn't going to use the standard one, because it's easier to get around. Quite interesting. And then as to the age verification that is anonymous, think of the technical challenge of doing that. And to ensure that someone is less than 16, the person applying is going to have to provide personal information, personal identifiable information about the person, saying, I'm really over 16, you see. This is going to be a challenge. So that's one thing where you have to supply personal information even to be declared to be over 16. This is going to get very interesting how this works out in practice. Then, if an account is accepted, the social media platform has to know, or if it knows or has reason to know that someone younger than 16 is using it, and there's a 90-day period to dispute age questions, that'll have to be resolved. Then what happens? Well, the account holder, if it's a person younger than 16, they can request termination of the account. Say, I'm done with Facebook, I want to get out of it, whatever the platform. Or a parent or guardian can do the same. They can request the minor account be terminated, even if the child wants to continue it, you see. So you have to start asking yourself, whose data is being protected here? Is it the child's? Is it the parents? Do the parents own the data of the child? What happens when the child turns 16 years in one day? There are all these questions. Whose data really is being protected here? There are, of course, violations and fines, $50,000 per violation involved, plus attorney fees. And there can be private suits. There can be punitive damages if a social media platform is engaged in knowing or reckless conduct about all of this kind of stuff. Then there's another reference in a section of the act that only U.S. companies are the ones that can do this anonymous age verification. Because as I mentioned, to get it, whoever's doing the anonymous age verifying is going to have to get personal information that would say, yes, in this case, this person's age is over or under 16, you see. And so Florida is saying, we don't want this to go out of the country. Well, this is going to get into, now here's Florida's getting into international business, isn't it? So there are privacy issues there. Well, just think for a minute of these privacy issues as we go through this, because there's no doubt that there are potential mental health and safety risks to young people of prolonged social media use. And we know from, say, a Pew Research survey in 2023 that 1/3 of teens aged 13 to 17 use the most popular social media platforms almost constantly. With smartphone ownership among teens nearly universal. So we know this happens, and it's something that legislatures and states should deal with, and the federal government as well. But just think of the privacy issues here. The first one occurs to me is, well, whose privacy is this? The child's, the parents, both together? How do you measure that? Secondly, a parent or guardian is going to be able to request termination of the account and deletion of data. Well, what if the minor doesn't want it deleted? Or flip it around. The minor wants to delete it, but the parent objects. They want to keep the data of their child. Well, not addressed by the Florida Act. And then the social media platform must delete permanently all personal information that's provided on the request, either of the youngster or the parent or guardian. Well, what if one wants to keep it and the other wants it permanently deleted? What happens? Probably has to permanently delete it. But think for a minute, what does that mean? You're permanently deleting from the platform things that have been shared potentially with millions of people. I mean, the data's loose. Can you really retrieve the privacy? Can you be forgotten in the digital age? It's a real question. So these are all troubling questions in here that Governor DeSantis is going to have to think about, and so are legislators, the U.S. government, and otherwise. Of course, we do have a federal act that applies to children younger than 13 years of age. But now we're into children on a state level under 16 years old in Florida's case, in some states under 18. Yugo, what do you think about this?
So, Joe, I find it interesting because with COPA, there is always the verifiable consent is always a difficult aspect for a lot of.
That's in COPA, dear listeners. That's the federal act, Yugo.
That's correct. And now, as you pointed out, the technical challenges of anonymous checking of age, followed by again, if a parent is going to be involved, there must be a verifiable consent. In order to delete, access, or even have an account for someone who's under 16, in Florida, it's got to be very difficult. And the issues that just to get over the hurdle to figure out anonymous checking or standard checking is going to be very difficult. So this might put a lot of pressure on social media services. And I guess the big platforms will be able to do it, but with smaller platforms that may be considered social media platforms, they may have difficulty staying in Florida, and that may cause other issues.
Yeah, now Meta, opposed the act because it said it would limit parental discretion. Well, very clearly it would do that, and would also raise data privacy concerns rather than solve them because of the personal information that is going to have to be provided in order to get age verified. So in trying to advance an interest, government may actually be putting at risk some personal information and the data privacy. Meta added that it will support federal legislation for online app stores to secure parental approval for downloads by people younger than 16. So you can see I'll add that 40 states out of the 50 have sued Meta on one basis or another for social media overuse by minors. So it's a real issue. Any concluding thoughts you have, Yugo?
Yes, well, we're coming to a point where privacy is, as we saw in the enforcement and as we're seeing these laws implemented, privacy becoming an important discussion in our daily lives, which wasn't happening, 2, 3 years ago. So it's fascinating to see the developments and how it sometimes restrictions go right up against our privacy rights, and other times we're seeing our privacy rights being protected by government. But privacy is really becoming part of the business and part of our daily lives. And it's an interesting development that we're seeing in just the past month.
Yes, indeed. Well, it was quite a leap year, maybe a leap for more privacy focus in our lives and by legislators. Hope you enjoyed it, and I'll close, as I always do, by reminding us all, protecting your personal privacy begins with you.